Gunshot and Stab Wound Mandatory Disclosure Act. Oh, I think this is the third time I'm seeing this baby come around, because it first came up in connection with the Health Information Act review. And it was one of the considerations that we were making. And I thought that there'd been a private member's bill that had been introduced by the member for Edmonton Castle Downs, because I really, really hated that amendment coming forward under the Health Information Act. I think that it should have come forward as we now have it. So I'm willing to support a standalone bill that talks about reporting of gunshots and stab wounds. This is what we should have done from the get-go. So if the HIA didn't actually get changed as a result of the member's bill, and you know, maybe it died on the order paper, I just can't remember, but this is the appropriate way to do this, and this is the way they've done it in other provinces. And there's a number of arguments for and against it, but I think the ones that I'm paying attention to, what you're trying to balance here is the safety of society, the safety of the medical professionals that are dealing with someone, balanced against a reasonable protection of personal health information. And putting what was happening before was putting it in the Health Information Act, which was requiring health professionals to basically make a subjective and an unsubstantiated guess at something and basically tattle on a patient because they may or may not have received this wound in a particular way was really inappropriate. And I think since then we've now discovered that it's a very faulty way of being able to deal with this issue. This is the proper way to deal with this issue. So we have the emergency medical technicians regulation. As always with an act, you've got all the definitions up front. Then you've got what it doesn't apply to, which clearly is anything that's self-inflicted or intentional. The attempt there is to shield people who may be under a mental duress or mental illness, and to try and protect them from a sort of undue scrutiny given the situation. And then it goes on the mandatory disclosure that emergency medical personnel or the facility have to disclose to the local police service the person's name, whether what is it? Is it a gunshot or a stab wound? The location of the healthcare facility, the location, if it was reported by an ambulance driver, for example, where was the location that they attended the individual. And then, of course, the always included and never appropriate catch-all phrase that other information that may be required by the regs. And the disclosure can be made orally and some other sort of practical parts of this. And I think that this works better, although it's, I mean, to someone that wasn't used to the intricacies of this, having somebody do this kind of disclosure under a standalone act versus under the Health Information Act, who cares? It's about reporting somebody that's got a gunshot or stab wound. But the way it's done, I think, is very important. Now, some of the things we always need to be careful of is have we produced legislation that's charter-proof? And of course, whenever you're talking about disclosing information about someone or reporting them to the authorities in any way, have you made it charter-proof? And we're looking against, and I think what comes into play here is Section 7 and 8. So 8 is the right to be secure against unreasonable search or seizure, and the reasonable expectation of privacy. And I think even if mandatory gunshot reporting legislation did permit unreasonable seizure of health information, the legislation could be justified under Section 1 of the Charter. I mean, we're just trying to be common sense here. This is not about getting incredibly fancy about anything. It's, you know, if somebody comes into a medical establishment and they have an injury that's clearly as a result of a crime or an accident, you know, both of those things come into play here, and that's appropriate, that needs to be reported to the authorities. And nobody should be surprised about this. Actually, anybody that watches any kind of American crime television will be very familiar with this one because, you know, this kind of stuff is in place in a number of other jurisdictions. And I think, actually, in Canada, this is, my memory was that it was, yeah, here we go. 4 other provinces, Manitoba, Saskatchewan, Ontario, and Nova Scotia all have this kind of legislation in place. So we're not the first, but we're not the last on this one. And the compelling arguments for this are that it should increase the security for the personnel within and without the hospital and the medical facility. It should allow police to move quickly enough to preserve any kind of evidence that's available. You know, because once they're not going to interfere with medical personnel attending to someone, clearly, and you can lose evidence that way, but you know, as soon as possible to be able to get access to the individuals, and that's a part of what's considered here. And that I think it is considered a reasonable restriction on personal freedom and that disclosure of personal information. The Oakes test, which is commonly used to justify a charter breach, it has to be sufficiently important to override the right. Well, I think there's a number of arguments for that one around the safety of the medical personnel and whoever else was out there, because there could be someone else that wasn't found at the same time that could be the other end of that exchange, for example. And that the means chosen to achieve the objective must be proportional to both the objectives and the law. And so all this is saying is they have to report it or disclose it, but beyond that, it doesn't say anything else. And I'm usually pretty vigilant about you know, the charter rights and health information disclosures. But to me, this seemed to be reasonable, and I think we have enough expectations on our health personnel that we have to be giving them clarity. It has to be, they don't like being in the middle of something where they're not sure what they're supposed to be doing. So nice clean legislation is a help to them and allows them to know when to do their job, what exactly is expected of them. It's pretty clear in here. I hope that the regulations don't get unnecessarily complicated and complex, because again that makes it difficult for them to figure that stuff out. Even just all the information that you're carrying around in your head. And I mean, there's days, I swear, if I have to understand one more thing or there's one more bill tabled in this house, I'll forget how to walk. So I'm very sympathetic to medical personnel who are dealing with all kinds of procedures and treatments and other patients that are on the particular ward, and then they've got to remember a whole list of rules about how they're going to have to disclose something. So as simple and straightforward and uncomplicated as possible, while protecting somebody's and being reasonable about somebody's health information and their charter rights. So I am very willing to support this bill. I think this is far in preference to what was done before, if it was done, and I'm happy to support this in Committee of the Whole for Bill 46. Thank you. Oh, did you? Okay.